Dude. So, hello, magandang gabi sa inyo mga kaibigan. So, nandito tayo ngayon sa ating very last lecture video for the topic of law on corporations. Kasi, second to the last video pa lang to kasi yung ating very last lecture video will be this weekend yung about sa cooperatives. Gaya na sabi natin, short discussion lang naman siya. And, ano pa ba? So as I've said, di ba, yung cooperatives hindi ang kasama sa long quiz natin sa Friday. Pero kasama sa ating final exam next week, which will also be Friday. So with that, let us continue or let us finish our discussion for the law on corporations. So ito, Title 15, Foreign Corporations. Now, as you know, of course, mga corporations natin dito, hindi lang domestic kasi you will not label that as domestic kung siya lang nandyan. You will label that nabubulol na tayo kakasimula pa lang. Ililabel mo yan as domestic kapag may counterpart yan, which is, in this case, tawag natin foreign corporation. So with that, alam natin, since may designation tayo, foreign corporation, we know na foreign corporations also operate here in the Philippines, di ba? So, because of that fact, sa corporation code natin, even beforehand pa, nilagyan na ng title, nilagyan na ng provisions on how to regulate these foreign corporations. Now, sa ating revised corporation code of the Philippines, title 15 yung namamahala dyan. So, ito, start tayo with section 140. Now, Section 140 provides for the definition and rights of foreign corporations dito sa ating bansa. Now, for the purposes of this code, ang foreign corporation is one formed, organized, or existing under laws other than those of the Philippines, and whose laws allows Filipino citizens and corporations to do business in its own country or state. It shall have the right to transact business in the Philippines after obtaining license for the purpose in accordance with this code and a certificate of authority from the appropriate government agency. So, Section 140 provides for us the definition kung ano nga ba ang isang foreign corporation under the law of the Philippines. So, ito, definition. Now, with respect to a particular state, a foreign corporation is a corporation that is created by or under the laws of another state or another country. This is the traditional definition of term. So, alam natin, klarong-klaro, di ba? Yung mga corporations that was created under the laws of the Philippines, tawag natin domestic. Dito sila ginawa. Pero yung mga corporations that was incorporated under the laws of another country, foreign sila. So, for licensing purposes, yung corporation code natin under this section defines a foreign corporation that is one, formed, organized, or existing under any laws other than the Philippines and whose laws allow, whose laws allow Filipino citizens or corporations to do business in its own country or state. Yan yung reciprocity na dito sa atin, if the foreign country does not allow Filipino citizens and corporations to work there, hindi rin natin sila i-allow dito. So dapat may mutuality yan, may reciprocity ang tawag dyan. So kung gagawin mo to, gagawin ko rin to. Quits tayo. Parang gano'n, reciprocity. So kung hayaan mong pagtrabahuhin yung mga constituents ko dyan sa bansa mo, hayaan ko rin pagtrabahuhin yung mga constituents mo dito sa bansa ko. Yon, reciprocity. So pag hindi ina-allow ng foreign country, yung corporations natin or yung citizens natin na magtrabaho doon, hindi natin i-allow dito. Reciprocity yun. So, under the incorporation test, this is a test in determination kung sino yung may-ari ng corporation, which we will later on discuss. Under the incorporation test, a corporation that is organized under the laws of the Philippines is a domestic corporation. Ito, nasabi natin. And with respect to the Philippines and a foreign corporation with reference to another state, if naman it is organized under the laws of another country, then it is a domestic corporation for said country. Pagdating sa atin, foreign siya. Pero domestic siya for the said foreign country. Now, during wartime, For reasons of national security, of course, to protect the yung control test ang gagamitin and not the incorporation test. Kasi 'di ba, ang incorporation test kung saan na-incorporate yung corporation, then doon yung lugar niya. 'Di ba? Doon siya nag-exist. Pagdating sa control test, ang titingnan mo, i-determine mo yung nationality ng corporation. Meaning yan, titingnan mo kung sino yung mga may-ari niyan, yung controlling stockholders. Kung sinong may-ari ng kung sino yung controlling stockholders niyan, yun yung national identity ng controlling stockholders ng corporation na yan. Yun yung magiging national identity ng corporation. So kung yung controlling stockholders ng isang corporation dito sa Pilipinas is mga Japanese, then during wartime, kahit na domestic corporation yan dito, na-incorporate under our country, under our laws, pero kapag yung controlling stockholders niyan are Japanese, then during wartime, it will be considered as a Japanese corporation for the protection of national security. Di ba? Pero during wartime, usually ganyan. Pero pag peacetime naman, kung saan na-incorporate, then yun yung lugar niya. So kung na-incorporate yung corporation sa US, then US corporation. Kung na-incorporate sa Japan, then Japanese corporation. Pag na-incorporate sa Pinas, di Pinas corporation yan. Now, corporation may operate within the jurisdiction of another state. Alam natin, globalization na tayo ngayon. So very interrelated, di ba? Interconnected yung trade natin. So as a rule, a foreign corporation can have no legal existence or status beyond the bounds of the state or sovereignty by which it is created or incorporated and organized. So within the jurisdiction lang daw kung saang bansa siya, saang state siya na organize. It exists only in contemplation of law and by force of the law, and where the law ceases to operate, the corporation can have no existence. So basically, very conservative yan eh. Very conservative principle yan. Parang sinasabi mo, itong US corporation, it only exists within the borders of the United States. Itong Philippine corporation, it only exists within the borders of the Philippine state. Paglabas yan, sa jurisdiction ng bansa, hindi na siya may tatrato as a corporation. That is a very conservative view. So, ito papasok yung principle ng consent doctrine. Knowing na very dynamic na yung globalization natin, as we have said, interrelated, interconnected. So, don't expect na kung yung mga corporations dyan sa bansa mo is only domestic lahat. May mga foreign din dyan. Now, this principle, however, does not prevent a corporation from acting in another state or country with the latter expressman or implied consent. So, this is the consent doctrine which is provided under Section 142 and 114 ng ating code, but every power which a corporation exercises, such as in the another state, depends for its validity upon the laws of the sovereignty in which it is exercised. So, because of the consent of other states to allow foreign corporations to operate within their borders, nakaka-operate pa rin itong mga foreign corporations na to kahit na nasa labas na sila ng kanilang home country. This is because of the reason of the consent doctrine. Hinayaan, binigyan ng consent. Yung consent na yun, whether express man or implied. The state in extending to foreign corporations the privilege of doing business may impress such privilege with whatever conditions and restrictions it deems fit to impose, under which the corporation will be granted the privilege. The condition, of course, must be reasonable. So basically lang siya sabi niyan, so ikaw foreign corporation, hinahayaan ka naming mag-operate dito sa bansa namin. But take note, we will regulate you. We will not let you do anything you want to do. We will regulate you. Limitado lang ang pwede mong gawin based on the laws of our country. But don't worry, those laws and conditions must be reasonable or will be reasonable. So, objectives of regulation, tinasabi natin. Bakit natin kailangan i-regulate itong mga foreign corporation? Now, the objectives of the statutory provisions prescribing conditions under which foreign corporations are permitted to do business in the state other than the state where they were created have been stated as follow. Ito yung mga reasons bakit natin kailangan i-regulate itong mga foreign corporations kapag hinayaan natin sila o binigyan natin sila ng consent para pumasok sa ating bansa. The first one is to place them on an equality with domestic corporation. So, walang lamangan to dito. Pareho kayong corporation, domestic man or foreign. To subject them to inspection so that their condition may be known. Kasi, by regulating them, these foreign corporations, we allow them or we impose our jurisdiction over them. Kasi, binigyan natin sila ng permiso mag-operate dito. So, in relation to that, dapat may jurisdiction tayo over them when they operate here in the Philippines. So, with that, they are subject to inspection. Mga inspection of their books, di ba? Pag-operate din sa Pilipinas, inspection ng kanilang facilities for regulation or regulatory purposes, di ba? And to protect the resident of the state doing business with them by subjecting them to the courts of the state. Provisions of revenue requiring the payment of fees and taxes are only incidental. Yun yung sasabi natin. We need to regulate them to subject them into our jurisdiction. And when we subject them into our jurisdiction, we can make them equal with other corporations, we can inspect them, and we can we can subject them to the courts. Kung may reklamo kayo, madala mo yun sila sa korte. Wala silang immunity. Kasi may jurisdiction tayo over sa kanila. So, pwede mo silang idala sa korte, magreklamo ka. Pwede. Kasi they are under the jurisdiction of our country. License and certificate of authority required of foreign corporations. Na ito, basta-basta lang ba natin hinahayaan under our laws to let these foreign corporations operate? Hindi. Kailangan bago sila maka-validly or legally operate dito sa bansa natin, kailangan mayroon muna silang license galing sa Securities and Exchange Commission. So under Section 140, foreign corporations shall not be permitted to transact or do business in the Philippines until they have secured. Bawal na bawal. Kailangan munang magkaroon sila ng license for that purpose that is provided by the Securities and Exchange Commission and a certificate of authority from an appropriate government agency. Kung banking foreign corporation man yan, then dapat may authority din yan galing sa central bank. Kung insurance corporation yan, sa insurance commission natin yan. Kapag kailangan ng authority from the appropriate agency. Now the fact, however, that a corporation may not transact business in the Philippines unless it has obtained license for that purpose nor maintain a suit in Philippine courts for recovery of any debt, claim, or demand without such license does not make such corporation any less a juridical person. Kahit na hindi yan binigyan ng license, does not necessarily mean na hindi siya juridical license. Bakit ito kasing license na to? It is only there para yung corporations will be permitted to transact and do business. It does not necessarily mean that it gives the corporation its juridical person. It only gives the corporation the privilege to operate here in the country. Kaya dito wala nagsasabi, kahit na wala kang license, don't worry, you're still treated as a juridical person. Hindi ka lang nga allowed pag mag-operate dito kapag wala kang license. So in relation to that, indeed, an exception of the license requirement has been recognized where a foreign corporation sues on an isolated transaction. So anong meaning yan? For example, sabihin natin ano bang maganda? Let us assume this Louis Vuitton. Assumption lang na itong si Louis Vuitton wala siyang operation dito sa bansa natin. Foreign corporation yan. Wala siyang operation dito sa bansa natin. However, this Louis Vuitton, may nakarating information sa kanya na may factory dito sa bansa natin na gumagawa ng fake Louis Vuitton products. So nakarating yung information na yan kay Louis Vuitton. So si Louis Vuitton, ayaw niyan Ayaw niyang pinipeke yung kanyang products, pinapirate. So yun, nakipag-contact siya dito sa Pilipinas, sa Philippine authorities, para isumbong. Sabihin na, merong factory dyan sa inyo. There's a factory there in your country that is creating or producing Louis Vuitton products. So, we are requesting na please close that factory and put those responsible in prison. So, ganun. So, in that case, kahit na walang operations license dito si Louis Vuitton sa ating bansa to operate, it does not necessarily mean na hindi siya pwedeng mag-file ng kaso. Because in this isolated transaction, pwede. Kasi pinipeke yung products niya eh. So, pwede siyang magreklamo. O yun, ganon. Isolated transaction. Pwede niyang habulin yun sila dito. Now, determination of nationality. As we have said, there are two rules in determining the nationality of the corporation, yung incorporation and yung control. Basically, yung incorporation, yung nationality ng corporation is based on the place kung saan siya na-incorporate. So, kung sa Pilipinas siya na-incorporate, then Philippine Corporation. Kung sa US siya na-incorporate, then US. Kung sa Japan, edi Japan. Pagdating ng control test, wala tayong pake kung saan niya na-incorporate. Ang tinitingnan natin, yung nationality ng controlling stockholders. So kung kahit na domestic corporation niya dito sa Pilipinas, na-incorporate yan dito, pero kapag yung controlling stockholders, mga Japanese, gaya na sabi natin, edi Japanese corporation yan. This application of either test depends on the particular situation. So sa atin, pag peacetime, it's the incorporation test. Pero pag wartime, for the protection of the national security, control test. Ito, Section 141 provides for the application to existing foreign corporations, so etc. na to. Every foreign corporation which on the date of the effectivity of this code is authorized to do business sa Philippines under a license issued to etc. Read na lang yan. Ito, Section 142 talks about the application of a license. So, isubmit sa tawag ito? Yung foreign corporation, mag-a-apply for a license to transact business in the Philippines, sasubmit sa Securities Exchange Commission, kasama ng kanyang bylaw, certified, itong nilalaman, etc. Sir, ni-skip mo man, sir. Ito naman, Section 140 talks about the issuance of the license. Sir, ni-skip nyo man, sir. Ni-skip nyo man. Ito namang Section 144 talks about the resident agent, kung saan pwede individual person or domestic corporation. Sir, nag-skip na naman kayo, sir. Ito naman talks about the resident agent and the service process. Sir, bakit kayo nag-skip? Kasi dito na agad. Mahaba-haba yan. Kung babasahin natin, i-repeat naman natin pagdating dito. Diba? So, saan na yun? So, application for and issuance of license, diba? As we have said, bago makapag-transact legally dito sa Pilipinas itong foreign corporation, kailangan niya munang makakuha ng license galing sa Securities and Exchange Commission and an authority from the appropriate government agency if kailangan. Kung banking corporation yan, central bank kukuha, etc. So, for the application for and issuance of the license, a foreign corporation applying for a license to transact business in the Philippines must comply with the following requirements and conditions precedent to the issuance of the license by the Securities and Exchange Commission. Ito, the submission of required documents. So, yung foreign corporation, if ninais niyang mag-operate sa Pilipinas, then, that's too big. Then, kailangan niya magsabit ng required documents sa Securities Exchange Commission, gaya ng certified copy ng kanyang articles of incorporation, kung saan man siya incorporate, with translation to an official language of the Philippines, so most probably English yan, if necessary, and the application for a license which shall be under oath and shall be specifically set forth the matters enumerated by law, yung sa previous sections unless already stated sa kanyang articles of incorporation. Then ito naman yung mga accompanying documents kasama ng kanyang application, to under oath or statement, etc. Then compliance with provisions of special laws, foreign banking man yan, financial and insurance corporation shall, in addition to the above requirements, comply with the provisions of existing laws applicable to them. So dito sa atin, ang mga foreign banks natin, JP Morgan, Wells Fargo, kung gusto nyo, Social, Bank of America, ano pa ba yung isa doon? Bank of China, Bangkok Bank ba yun? Bank of Bangkok. Bank of Bangkok. Yung Thailand, capital ng Thailand. Kasi marami tayo dito foreign banks. Pero usually, they don't deal with commercial banking with Filipino citizens. Usually sa mga other corporations din yan, sa governments, doon yan sila nakikipag-deal. Hindi sa mga commercial banking with ordinary people like us. So, issuance of license to transact business. Now, if the applicant shows to the satisfaction of the commission na it has complied with the above requirements sa mga previous section natin, from 142 to 145, then those imposed by other rules and regulations, gaya ng mga special laws natin, sabi ni commission, goods naman tong foreign corporation na to. So, the commission shall issue a license authorizing ito transact business sa Philippines for the purpose or purpose specified therein. So kapag ang purpose na is foreign banking, so banking purposes, di ba? Kung food, edi food. Now, condition subsequent to issuance of license. So ganito yan. Parang sa pagiging CPA, pagiging lawyer. Kahit na you were able to get the title, you're CPA, you're a lawyer, it does not necessarily mean na pwede ka naman loko. Dapat may continuing good standing ka. Kasi pag nasira yung continuing good standing mo, pwedeng kunin sa'yo yung license mo. Similar dito. Condition subsequent to issuance of the license. Just because the foreign corporation, was able to get the license, it does not necessarily mean na pwede na yung loko. Kailangan that corporation must maintain a good standing in order to retain his license. Upon the issuance of the license, the foreign corporation may commence to transact business sa Philippines and continue to do so for so long as it retains the authority to act as a corporation under the laws of the state of its incorporation unless such license is surrendered, revoked, suspended, or annulled in accordance with the code or other special laws. So the foreign corporation shall transact business only for the purpose or purposes which is authorized under its license. So gaya na sabi natin, kung banking yan, banking lang. Hindi siya pwedeng magpunta sa agricultural, etc. etc. Ito mahalaga to. Na sa previous sections to, under between 142 and 145. So within 60 days after the issuance of the license, the licensee, except for foreign banking or issuance corporation kasi they are governed by other laws, by special laws, this foreign corporation shall deposit with the Securities Exchange Commission for the benefit of present and future creditors in the Philippines satisfactory securities in the actual market value of at least 500K. The deposit requirement is also means of compelling foreign firms to invest in or buy Philippine securities. Ano meaning yan, sir? Meaning lang yan. Sige, bigyan ka namin ng license. So, nabigyan na ng license. Within 60 days, kailangan mag-provide ng securities si foreign corporation. Bakit sir? Ano yung meaning yan, sir? Para if, for example, itong si foreign corporation, biglang tumakas, siyempre, mahirap pinabulin foreign corporation yan So, kahit na bigla siyang tumakas, mahirap din habulin, gaya ng sabi natin. So, yung pambayad sa damages na na-cost niya, kukunin na lang sa securities na binigay niya. Ganon yun. Ganon yung pinepertain ng mga securities. So kahit na tumakas yan si foreign corporation and considering na foreign yan, mahirap yan habulin, then at least naiwan niya yung securities niya. Naiwan niya yung securities niya. So kahit na umalis siya, mahirap siya habulin, yung mga damages na na-cost niya, doon kukunin sa securities. Yun yung purpose nito. Within 6 months after its fiscal year of the license, it shall deposit additional securities, in the market value 2%, the amount of the amount by which the licensee's gross income for the fiscal year exceeds 10 million. Ito, pag kino-continue yung business dito sa Pilipinas, then mag-deposit siya ng additional securities. So yan, para pag tumakas siya, may makukuha pa rin tayo. Para hindi tayo lugi dito sa Pinas. It must comply with the provisions of existing laws, rules, and regulations. Otherwise, its license may be revoked, suspended, or annulled by the Securities Exchange Commission. Gaya na sabi natin, just because he was able to get the license does not necessarily mean na pwede na siyang manloko. Kailangan i-maintain niya yung kanyang good standing in order to retain the license. In order for him to be permitted to transact business here in the Philippines for the purpose or purposes, it was allowed to do so. Ito naman, resident agent. Sir, na-skip natin si resident agent sa pag-skip nyo ng section. So, ano ba yung resident agent, sir? So, si resident agent, basically, without reading this, siya yung representative ng foreign corporation dito sa Pinas. Yun basically si resident agent. And I know, medyo familiar kayo sa resident agent kasi baka na-mention to sa business tax nyo. Oo, sa business in income, business tax nyo, oo, doon si resident agent. Sa mga PEZA part na to. So, si resident agent is an individual who must be of good moral character and of sound fiscal standing. So, may requirement. Good moral character and fiscal standing, and also must be residing in the Philippines kapag individual. Or, si resident agent pwede rin maging isang domestic corporation that lawfully transacting business here in the Philippines. So, yan si resident agent. Dalawa siya pwede. Individual na may good moral, residing sa Philippines and may sound financial standing, or pwede rin siyang maging domestic corporation that is lawfully transacting business here in the Philippines. To which designated in a written power of attorney, itong si resident agent, by a foreign corporation authorized to transact business here in the Philippines, on whom any summons and other legal processes may be served in all actions or other legal proceedings against the corporation. Against such foreign corporation, meaning, kapag merong hahain kayo ng summons, no, other legal processes na kailangan ibigay kay foreign corporation na considering foreign corporation so mahirap tong mahirap tong hanapin, mahirap tong haian, ano tawag ito? Mahirap tong hainan ng legal documents. So para mas mapadali yung process, si resident agent sa kanya ibibigay. Yun. Kasi si resident agent basically the representative of the foreign corporation in the Philippines. Now the primary function of a resident agent is to receive in behalf of a foreign corporation notices, summons, and other legal processes in connection with actions against such corporation. So representative siya, taga-receive siya, yun yung main trabaho niya. Bakit? Kasi the moment na submit na kay nabigay na kay resident agent, it is as if nabigay na kay foreign corporation. So agent siya dito. So pag nabigay na yung legal document kay resident agent, it is as if that it was given to the foreign corporation directly. Ganon yung essence niyan. Now, si resident agent of course wala siyang control over the assets of the corporation. Representative lang siya kumbaga. The agent of the corporation here in the Philippines. Now, the service of any such papers on such resident agent has the same force and effect as if made upon the duly authorized officers of the foreign corporation at its home office. So, yun sasabi natin. Now, what's the purpose of law? Parang nasabi natin to. On requiring licenses. The object of the statute in requiring that foreign corporation doing business here in the country be licensed to do so and that they appoint an agent for the for service or process is to subject the foreign corporation doing business in the Philippines to the jurisdiction para ma-regulate natin sila. It is not to prevent the foreign corporation from performing single or selected acts, but to bar it from acquiring a domicile for the purpose of business without taking steps necessary to render it amenable to suit in the local courts. Meaning, pag i-allow mo yan to operate here in the Philippines, siyempre dapat di lang yan basta-basta maka-operate dito. You must subject it to the regulatory powers of the government para mapunta yan, masubject yan to our jurisdiction para ma-regulate, para hindi yan magloko. Basically, ganun yung purpose yan. Now, meaning of transacting business. To concept na lang to. Circumstances case, acts included as provided sa Omnibus Investment Code and Foreign Investment Act of 1991 and acts not included. So yan. So let's go to section 146. Law applicable. So ano ba tong sabi ni section 146 about sa law applicable? Now, ang foreign corporation daw lawfully doing business in our country shall be bound by all laws, rules, and regulations applicable to domestic corporations of the same class, except those which provides for the creation, formation, organization, or dissolution of corporation, or those which fix the relation, liabilities, responsibilities, or duties of stockholders, members, or officers of corporations to each other or to the corporation. So, meaning lang yan, kahit hindi na ito basahin, na meaning lang yan, when it comes to the operational, yung mga operations, transaction matters ng foreign corporation dito sa bansa natin, yung Philippine laws yung mag-apply. But when it comes to the organizational or internal matters, affairs ng corporation, ng foreign corporation na yan, then yung laws of state of creation, kung saan siya nilikha, saan siya na-incorporate, yun yung magmamatter, yun yung mag-a-apply. So, when it comes to operations and transactions dito sa bansa natin, Philippine laws ang mag-a-apply sa foreign corporation. When it comes to their organizational, internal matters, internal affairs, then yung laws of the state in which the foreign corporation was created. Ito naman, it is a well set pagdating sa proof of foreign laws dito sa bansa natin. Just because foreign law yan, or just because that is an established law on the foreign country, does not necessarily mean that it is already applicable and approved dito sa ating bansa. Because yan yung sabi ng ating jurisprudence dito sa Pilipinas. So with that, ang gagawin pag gusto mo i-assert yung foreign law na yan dito sa bansa natin, you need to allege and prove that in the court. Pag hindi mo yung ginawa, then it is not recognizable dito sa country natin. Sana magandang example yan, sir. Ito ganito. 'Di ba? Sa ating bansa, hindi allowed yung divorce, 'di ba? Pero sa ibang bansa allowed 'yan. So, there are many instances na yung mga tao sa ibang bansa, doon sila magde-divorce. Doon sa bansa na 'yon, yes, tawag dito, recognizable yung divorce na 'yon. Pero pagdating sa Pilipinas, kapag hindi mo yan dinaan sa korte para yung korte mag-recognize diyan, judicial notice ang tawag natin doon, hindi yan recognizable dito sa Pinas. O kailangan mo na may judicial notice yan. Na sinabi ng korte, okay, we notice that, we recognize that. So pag na-recognize yung divorce na-recognize ng korte dito sa bansa, yung divorce na ginawa nyo sa ibang bansa, then it is tawag ito, then it is applicable na rin dito. Pero kapag walang judicial notice, hindi yan applicable dito sa bansa. Doon lang sa kung foreign na bansa kung saan nakuha yung divorce. So ganun basically yung proof of foreign laws natin. So now, syempre, hindi lang dito sa Pinas nagkakaroon ng amendments sa isang corporation. Nangyayari rin yan sa ibang bansa. So what would happen kapag yung foreign corporation na nagtatransact dito sa Pilipinas nagkaroon ng amendment sa kanyang AOI or bylaws from his home country? So Section 147 provides for that. Amendments to the Articles of Incorporation or bylaws of foreign corporations. Now, whenever the Articles of Incorporation or bylaws of foreign corporation authorized to transact business dito sa bansa are amended, then such foreign corporation shall within 60 days from the amendment becomes effective, malay mo dun sa ibang bansa mag-file ng excuse me po. File pag 60 days after the amendment becomes effective sa home country niya, then the foreign corporation transacting business here in the Philippines shall file with the commission and in the proper cases with the appropriate government agency a duly authenticated copy of the amended AOI or bylaws indicating clearly in capital letters or underscoring the change or changes that was made. That is duly certified by the authorized official or officials of the country or state of incorporation. Like baka may Securities Exchange Commission din sila doon, di ba ganun? Sa Amerika meron silang ganun. Such filing shall not in itself enlarge to or alter the purpose or purposes for which such corporation is authorized to transact business here in the Philippines. So effectivity, di ba? Basically, within 60 days from the effectivity, magfa-file sa commission in regards to that. Ngayon, there's a need to amend the license kapag yung kapag the filing of the amended AOI or bylaws by the foreign corporation, however, does not itself enlarge or alter the purpose for which storage now it must first obtain an amended license showing that the other additional purposes which it intends to pursue in the transaction of business sa Pilipinas. Otherwise, its license shall be subject to revocation by the commission. So, kailangan ng amended license, lalo na kapag meron kang ibang purpose or additional purpose sa gusto mong gawin dito sa bansa natin. Kapag hindi mo yung ginawa, then it will be subject to revocation. Babawiin yan. Now, amended license. A foreign corporation authorized to transact business dito sa Pinas shall obtain an amended license in the event it changes its corporate name or desire to pursue other or additional purposes sa bansa natin by submitting an application with the Commission favorably endorsed by the appropriate government agency. Now, Section 149 talks about the merger or consolidation involving a foreign corporation licensed in the Philippines. So yeah, pwede rin. Applicable yan sa atin na isang foreign corporation ma-involve sa isang merger or consolidation. Na dalawa yan. This foreign corporation in its home country will merge or consolidate with another foreign corporation. Second instance is this foreign corporation will merge or consolidate with a domestic corporation sa ating bansa. So anong mangyayari in those cases? Natandaan natin, ang merger, di ba? Yan yung pinapatay mo. Hindi, joke lang. Yan yung A plus B is equals to A or B. Ang consolidation, A plus B is equals to C. Yun. So, no, naalala ko talaga yung formula na yan pagdating sa merger consolidation kasi nagmali ako dyan sa long quiz. Mas malaking points ba yan? One or more foreign corporations authorized to transact business in the Philippines may merge or consolidate with any domestic corporation or corporations if permitted under the Philippine laws and by the laws of its incorporation. So, both the Philippine laws and the laws of its home country if permitted. So, provided that the requirements on merger consolidation as provided in this code are followed. Now, yan yung una. Foreign and domestic. Now, whenever a foreign corporation authorized to transact business here in the country shall be a party to a merger consolidation in its home country or state, so doon sa kanila, as permitted by the law authorizing its incorporation, then ang gagawin ng foreign corporation na to shall, within 60 days after the effectivity of the merger consolidation, file with the Commission and in proper cases with the appropriate government agency a copy of the articles of merger consolidation duly authenticated by the proper officials of the home country kung saan sila nag-consolidate, provided however that if the absorbed corporation, ibig sabihin A plus B, tapos si foreign corporation is B, tapos yung naging result is equals to A, di ba? Nag-merger sila. So nawala na na-absorb na si foreign corporation. Now, pag ano yung nangyari, this foreign corporation doing business in the Philippines, ang mangyari, the latter shall at the same time file a petition for withdrawal of its license in accordance with its title. Yun ang gagawin niya. Kasi inabsorb na siya wala na siyang sariling sariling personality. So, hindi na continue pa doing, hindi maka-continue. Nag-iba na yung personality niya. So, if gusto niya pa mag-continue sa doing business here in the Philippines, since nandito naman yung operations niya, then withdraw siya, then mag-file siya ng additional petition for license. Parang ganun lang. Merger or consolidation. Ito napag-usapan natin. Now to, sir, napag-uusapan natin na yung license na yan. What if, sir, ano mangyayari if a corporation does business here in if a foreign corporation does business here in our country without a license, what are the repercussions? Provided naman din dito sa Title 15. So dito tayo sa Section 150, doing business without a license. No foreign corporation transacting business here in the Philippines without a license or its successors or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines. Hindi siya pwedeng maghabol. But, kasi wala siyang license so hindi siya under the regular, wala siyang karapatan basically. But such corporation may be sued or proceeded against before Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. So, basically, ganyan yan. Kapag wala kang license, foreign corporation ka, do business ka dito sa bansa namin, hindi ka pwedeng manghabol, pero pwede kang habulin. At least hinahabol. So, Section 1, effects of doing business without a license. Section 150 states the effect of the following. Suit by a foreign corporation. Ibig sabihin si foreign corporation yung magsasampa ng kaso, maghahabol. The foreign corporation transacting business without a license or its successors assigns shall not be permitted, subject to certain exceptions. Yung gaya na sabi natin kanina kay Louis Vuitton, di ba? Pero dito kasi, transacting business tapos wala kang permit, wala kang license, no? Anong karapatang mo maghabol? Hindi ka binigyan ng license So, itong si foreign corporation shall not be permitted, subject to certain exceptions, to maintain or intervene in any action, suit, or proceedings in any court or administrative agency of the Philippines. So, hindi siya pwedeng manghabol. Hindi siya pwedeng umepal. Parang ganun. Ngayon, what if the suit is against the foreign corporation? Then, in that cases, si foreign corporation pwede siyang habulin. The foreign such corporation, however, may be sued or proceeded against before the Philippine courts or administrative tribunals on any valid cause of action recognized under the Philippine laws. So yan Si foreign corporation doing business here in the country, hindi pwedeng manghabol, subject to certain exceptions. Pero pwede siyang habulin. Furthermore, it is implied from the rule established in Section 140 that the foreign corporation shall not be permitted to continue transacting business here in the country unless it shall obtain a license required by law. Until it complies with the law, shall not be permitted to maintain suit in any local courts. Now, but take note, syempre may exceptions tayo, subject to certain exceptions. Ito na yun. A suit by an unlicensed foreign corporation. Now, suit by an unlicensed foreign corporation. Now, take note, it is not the lack of the prescribed license to do business in the Philippines, but doing business without such a license which bars a foreign corporation from access to our courts. It is not the lack of the mali ng English nito. It is not the lack of the prescribed license, but doing business without such a license which bars. Okay, gets. So, dalawa ang problema dito. Yung una, wala ka lang license. Yung pangalawa, wala ka ng license, you're doing business here in the country. So, yung second one, yung problema. Walang license, then doing business. Yun yung problema. Dito yan nag-a-apply. Kaya, which bars of foreign corporations from access to our court? Diba guys, sabi natin, you're doing business without a license. Hindi ka pwede maghabol. Pero pwede kang habulin. So, yung isang instance naman, hindi ka naman nagdo-do business dito. Hindi ka naman nagdo-do business here in the country. So, tawag sa'yo unlicensed foreign corporation pa rin, di ba? Kasi wala ka namang license Now, paano? Anong remedies? Anong pwedeng gawin? Anong suit ang pwedeng gawin ng mga unlicensed foreign corporation na hindi naman nagdo-do business here in the country? Kasi napag-usapan natin, di ba? Yung mga foreign corporations na wala lang license, nagdo-do business pa. So, dito tayo ngayon sa mga foreign corporations na wala lang license and not doing business. So, ganito ang mangyayari. Una, to seek redress for an isolated business transaction. The implication of the law is that it was never the purpose of the legislator to exclude a foreign corporation which happens to obtain an isolated order for business from the Philippines from receiving redress in the Philippines court, and thus in effect, to permit persons to avoid contracts made with such foreign corporation or shield debtors from their legitimate obligations. Meaning lang, isolated transaction. Meaning, isang beses lang nangyari. Na may nakita ka dito, may supplier dito ng buko. Sabi ni foreign corporation para sa kanyang sabi natin, food products ang binibenta niya. May nakita siyang supplier dito sa Pilipinas. Kasi yung supplier niya sa ibang bansa, medyo kinukulang. So, hahanap siya ng ibang supplier na mabilhan niya ng isang beses para i-augment yung kanyang lack of supply. So may nakita siya dito. Si foreign corporation may nagbenta. May nagbenta. So sabi niya, "Yo, what's up yo? You're selling these buko-buko. So we will buy that from you." So yun, bumili siya. Pero ang problema na dengoy siya. Nabayaran niya na hindi nabigay sa kanya yung order niya. So itong si foreign corporation, because of this isolated transaction lang naman kasi isang beses lang to para ma-augment niya lang yung lack of supply niya. So pwede siyang maghabol. O nag-transact nga siya pero hindi siya doing business here in the country. So may difference yun. Nag-transact siya pero hindi siya doing business. Kasi ito, isolated transaction lang. One time lang to augment his supply. So in that case, pwede niyang habulin yung buko supplier na yun na nagdengoy sa kanya. Ganon. To seek redress for an isolated business transaction. Ito naman to protect its corporate reputation, name, and goodwill. So similarly, an unlicensed foreign corporation which has never transacted business in the Philippines may maintain an action in our local courts for the purpose of protecting its reputation, corporate name, goodwill, selling importers within the country, products bearing core. Ito yung sasabi natin kanina. Diba yung si Louis Vuitton? Si Louis Vuitton, let's assume na hindi siya nagbebenta, wala siyang operations dito sa Pilipinas. Diba? Kasi, di ba, usually naman, yung mga celebrities natin sa ibang bansa bumibili ng luxury items, luxury brands, di ba? Most of the time, di ba? Pero let's assume si Louis Vuitton, si Hermes, wala silang operations, wala silang transaction, operations dito sa bansa natin. Pero may napansin sila or may information. Ito, similar, ganito, yung example natin kanina, may nag-inform sa kanila na may nangyayaring pagpipirata ng kanilang products dito sa bansa natin. Pinoproduce sa isang factory. So, in order to protect their corporate reputation, name, and goodwill against these fake products, pwede silang mag-file ng suit to protect themselves. Nga, uy, Philippine authority, one of the factory in your country is making fake products of is making fake copies of our products. So please, if you may, stop that operation. So yun, pwedeng gawin. To enforce its right not arising out of business transaction, non-exemption from suit in the Philippines, etc. etc. So the validity of contracts. So ulitin natin take note, may dalawa tayong pinag-usapan dito na unlicensed corporation. Yung una, unlicensed corporation na doing business in the country. Yung pangalawa, unlicensed corporation lang. Yung unlicensed corporation doing business in the country, ito sa kanya, ito yung nag-a-apply sa kanya. Hindi siya pwedeng maghabol, pero pwede siyang habulin. Ito naman, pinag-usapan dito, yung unlicensed foreign corporation lang, not doing business in the Philippines. So in those cases, pwede sila maghabol. Ito yung mga instances to seek redress for an isolated business transaction. Tandaan, this is not doing business talaga, but this is just an isolated business transaction. Ito to protect its corporate reputation. Ito. Now, the validity of contracts of unlicensed foreign corporation. Now, considering that they are unlicensed, then they made contracts, di ba, dito sa bansa natin. So, anong effect niyan? If the foreign corporation does business in the Philippines without obtaining the required license, so ibig sabihin doing business and walang license. So ano mangyayari dyan? Without obtaining required license, are contracts entered into by it in the course of its transacting business void or merely voidable or unenforceable? Now, anong difference sila? Diba si void, non-existent talaga siya at the very beginning. Invalid. Si voidable, di ba? Parang may vitiation may defect lang sa consent, di ba? Yun yung concept ni voidable. May defect lang sa consent. So either ma-ratify yan or i-annul, di ba? And yung unenforceable kasi hindi talaga siya ma-enforce at the first time, like may defect, tawag dito, yung parehong both parties are not able to give their consent, di ba? Sa voidable, yung isang party lang. Sa unenforceable, both parties. 'Di ba? Ano pa? 'Di ba yung 1/4 lesion, 'di ba? If you can still remember your obligations and contracts, 'di ba? Yun yung unenforceable. Tapos ano yung another form natin yung pang-apat, 'di ba? Yung rescissible contracts, 'di ba? Now, the corporation code is silent on this question while American decisions are all conflicting. So, basically ganito lang. Tingin tayo sa ibang batas natin sa civil code. Contract is void. Article 5 of the Civil Code provides as follow. Acts executed against the provisions of mandatory or prohibitory laws shall be void except when the law itself authorizes their validity. So it has been opined that under the above provision, such contract are void and therefore subsequent compliance with the legal requirement will not cure the defect of the contract. Kasi nga valid siya eh. Yeah, invalid nga siya eh. Now, contract which are valid as to innocent parties. So, if that's the case, yung isang party lang yung bad faith, yung guilty party, then a contract is valid to innocent party. Bakit? You need to protect their rights eh. Inosente sila. So, wag mo hayaan na pati yung inosente parusahan nyo. Yung guilty lang. So, it has been held, however, that such a contract shall prejudice only the guilty corporation and not the innocent parties who may have dealt with the said corporation in good faith. For it is unjust that the non-complying foreign corporation and the person standing in its shoes should escape liability on contracts had by it by setting up its non-compliance. So, innocent party, don't prejudice their rights. Contract enforceable upon compliance with the law. So, the better reason, the wiser and fairer policy, and the greater weight lie within the decision which hold there's prohibition with penalty, etc., etc. So ito, let's go to the section 151. Diba as we have said, itong license ng isang corporation, just because nakuha niya na yan, does not necessarily mean na pwede siyang manloko. Kasi pwede ang bawiin ng Securities and Exchange Commission. Kasi itong foreign corporations, they must maintain a good standing while doing business here in the country. Diba? Now, the power to revoke the license of the corporation is a power given to the Securities and Exchange Commission, and there are certain instances when the Securities and Exchange Commission can revoke such license. It is provided under Section 151. So, revocation of license without prejudice to so, dalawang pronunciation ko, no? Prejudice at prejudice. So, depende sa mood ko. Without prejudice to other grounds provided under special laws. The license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the Commission upon any of the following grounds. So, ito yung mga grounds na kung saan si Commission, pwede itong gamitin grounds na to revoke or suspend man lang yung license ng foreign corporation. Yung una, failure to file its annual report or pay any fees as required by the law. Failure to appoint and maintain a resident agent dito sa Pilipinas kasi provided na required ang title. Failure after change of its residence to submit a statement of such change. Failure to submit a commission authenticated copy ng kanyang amended AOI or bylaws. A misrepresentation of any material matter in an application, report affidavit, At so ito mga grounds, failure to pay, transacting business outside any other ground would render fit in the Philippines. So, ito. Grounds for revocation. Nakalist naman. So, Section 152 provides for the issuance of certificate of revocation. So, under the revocation of the license to transact business here in the Philippines, the Commission shall issue a corresponding certificate of revocation, furnishing a copy thereof to the appropriate government agency in the proper case kung under naman sa government agency corporation na yun. The Commission shall also mail the notice and copy of the certificate of revocation of the corporation as it is registered sa office dito sa Pilipinas. So yan, certificate of revocation kapag nag-decide yung commission na your license is revoked. Babawiin namin yan. So, what are the effects of revocation? Ano mangyayari pag na-revoke na yan? Excuse me po. So, the revocation of the license of a foreign corporation cannot affect the validity. So, take note dito. It cannot affect the validity of the contracts entered into before the revocation. Before the revocation. Nor its right to maintain an action to enforce them. So, before the revocation, valid pa rin yung mga contracts. It may still bring or maintain an action based on such contracts. Before the revocation Now, what happens after the revocation? But contracts entered into by it after revocation are invalid and unenforceable. Bakit? Kasi nung binawi na yung license na yan, wala nang karapatan si foreign corporation na mag-do business here in the country. So, because of that, invalid na and unenforceable yung kanyang mga pinasukang contracts. But, without prejudice to the rights of the innocent parties. Diba? Kasi napag-usapan dito. Huwag mong parusahan ng innocent party, yung guilty lang. So, as to such contracts, the effect is the same as if the license had never been granted to the foreign corporation. So, it has been opined, ito parang another theory to or another concept. However, that the revocation shall not affect the validity of contracts entered into by the foreign corporation after revocation. Uy, bakit? The only effect of the revocation is that the foreign corporation cannot seek redress from the court to enforce such contracts. It simply removes its legal standing to sue. If innocent parties can still enforce such contract, it really makes no difference whether they are considered valid or invalid. So, parang same sa sinabi din kanina, di ba? Yes, para rin siyang corporation na unlicensed doing business. So, ang problema, hindi siya pwede manghabol, pero pwede siyang habulin. Parang ganun. Pursuant to Section 150, such foreign corporation can no longer transact business here in the Philippines and it cannot maintain any suit or action in any court or administrative agency in the Philippines, although it may be sued on any valid cause of action. So, ito naman, our last section for Title 15. Siyempre, kapag papasok yan, pwede rin yang lumabas on its own. Kapag papasok yan, pwede rin lumabas on its own. So, Section 150 talks about the withdrawal of a foreign corporation. Like, pag gusto niyang mag-cease ng operations dito sa Pilipinas, so he can withdraw. Now, subject to the existing laws and regulations, a foreign corporation licensed to transact business here in the Philippines may be allowed to withdraw from the Philippines by filing a petition for withdrawal of license. No certificate of withdrawal shall be issued by the commission unless all of the following requirements are met. So, if the commission deems that the requirements are not met, then it will not allow the foreign corporation na umalis, na mag-withdraw. Na sir, kung gusto talaga ng foreign corporation, sir, so alis na lang siya. Hindi niya na lang hintayin yung tawag dito, yung certification ng withdrawal. Alis na lang siya. Hindi yung ganun kasimple. Bakit? Tandaan nyo, di ba may iniwang malaking securities itong foreign corporation dito sa Pinas, di ba? So kapag bigla lang yan sa alis, then sa atin na yung malaking amount ng securities. Di ba? Pero pag properly yung pag-withdraw niya, ibabalik yun sa kanya. Kasi securities lang yun eh. Di ba? So ito yung mga requirements. All claims which have accrued in the Philippines have been paid, compromised, or settled. All taxes imposed, assessment, and penalties, if any lawfully due to the Philippine government or any agencies have been paid. The petition for withdrawal license have been published. Ito, publication for a week for 3 weeks, consecutive weeks in a newspaper of general circulation in the Philippines. So, Section 153 prescribes for the rules of the withdrawal of the foreign corporation. Must be filed with the SEC with all requirements to ascertain na walang liabilities tira. The court may review, etc. etc. So, yun yung sinasabi natin. Para properly withdraw, magbawi niya yung kanyang security sa binayad. So basically, ganun lang yun eh. So with that, this is our last. So tapos tayo sa Title 15 ng Foreign Corporations. So, ito na lang yung remaining parts ng ating ng ating corporation code. Ito, bago to, investigation offenses and penalties. But this is, hindi na to pang accountant eh. Pang abogado na to, pang mga korte na to. So, if you want, you can read this for additional learnings, pero hindi na to siya ganun kahalaga kasi hindi naman kayo abogado as of now eh. Baka sa future. Yeah? Pero as of now, dito, iba na to, hindi na to under sa inyo. Pero I suggest, basahin nyo pa rin to. Baka may lalabas dito. Ito, mga cease and desist, investigation, prosecution, contempt, administrative sanctions. O, tingnan nyo, mga to eh. Pang-korte na to eh. Procedural matters na to. Violation, etc. etc. Engaging intermediaries, graft and corruption. Ito, miscellaneous provision. Meron nito sa natin, pero miscellaneous lang siya. So, additional readings lang to. Yan. O yan, no? Ito, powers and function of the and jurisdiction of the Securities Exchange Commission. Okay, examination result. Miscellaneous na lang yan. Ini-skip na yun ng mga abogado ito, mga miscellaneous, kasi hindi na importante. So ito, separability cost, pinirmahan ni Gloria. Speaker pa pala siya that time. Di speaker pala to. Ito. So, with that is our last lesson for, hindi this semester, second to the last lang to, for this, for this, tawag dito, ano topic to? For the Law on Corporations, the Revised Corporation Code of the Philippines, di ba? Republic Act 11232. So yan, natapos tayo sa law on sa relevant facts or relevant matters under the Revised Corporation Code of the Philippines. So for our long quiz this Friday, from Title 6 to the last discussion. Di ba? To the last discussion. Then next week, then sa weekend, ipopost ko yung lecture video for the cooperatives. Then don't forget, di ba? Don't forget about the requirement nyo sa make a corporation. Di ba? Pansin nyo, nakakatulong yun sa grades nyo. Then, Friday, next week, final exam tayo. Okay, reserve the date na, mga 12 siguro start, 12 p.m. And same rin sa long quiz natin sa Friday, 12 p.m. rin. So, don't forget. So, with that, good night. Bye-bye. Love you.